In our previous video, we have finished up to Article 48A of the Directive Principle of State Policy. And in this video, we will discuss first Article 49 of the Directive Principle of State Policy, which gives direction to the state that it shall be the obligation of the state to protect every monument or place or object of artistic or historic interest declared by or under law made by Parliament to be of national importance from spoliation, disfigurement, destruction, removal, disposal, or export as the case may be. So, in that connection, the Union Parliament and the Union Government or the center had taken many improving steps for the improvement of Indian culture and heritage and to keep it constant going on. It established Lalit Kala Academy, Sangeet Natak Academy, National Gallery of Modern Art, also Sahitya Academy, National Book Trust, and also the Parliament enacted Ancient Monuments and Archaeological Sites and Remains Act 1958, and subsequently this act was first amended in 2010, which defined prohibited area and regulated area in archaeological sites and remains. So, another amendment was brought in 2018, which defines what is public work and the very construction of public work in prohibited areas for public purposes is permitted to the state. And in consequence of this, all the monuments and heritage, ancient sites are protected under Ancient Monuments and Archaeological Sites and Remains Act 1958 under the jurisdiction of Archaeological Survey of India, which was initially established in 1861 by Alexander Cunningham, and in that connection, we would like to discuss one leading case, that is Rameswaran and Prarsi versus Union of India in 1989. The Supreme Court made observation on a public interest litigation regarding museum trust where it was expressed that the petition under Article 32 asserting it to be public interest litigation alleging arbitrary manner of running trust by Maharaja of Jaipur state is not maintainable. It does not violate Article 49 as it was pronounced by our Supreme Court. So now we'll go to another most important article that we found under the directive principle of state policy, and that is Article 50. And that Article 50 gives direction to the state that the state shall take steps to separate the judiciary from the executive in the public services of the state. So, in that connection, exactly one leading case where the separation of power between the executive, legislature, and as such between judiciary and executive, in which the Supreme Court pronounced, and that particular case is University of Kerala versus Council Principals Colleges of Kerala in 2010. The Supreme Court expressed that the separation of power has to be viewed through prism of constitutionalism and the upholding goals of justice in all its full magnitude as it was pronounced by our apex court in this important leading case. University of Kerala versus Council Principals Colleges Kerala in 2010. And now we'll go to another important leading case relating to separation of power in between judiciary and executive, and in that connection, the case is Balram Bali versus Union of India in 2007. Supreme Court made the observation that court cannot direct legislature to enact particular kind of laws. The prohibition of slaughter of cows, buffaloes, and horses cannot be imposed. Why could? It is a matter of policy of government as it was declared by the Supreme Court in this important leading case. Balram Bali versus Union of India in 2007, and another most important leading case in connection to the provisions of Article 50 regarding separation of power between judiciary and executive, that is Supreme Court advocates on records association versus Union of India in 1994. Supreme Court pronounced that in appointment of Supreme Court and High Court judges, the opinion of Chief Justice of India has primacy as it was declared by the Supreme Court in this important leading case. Supreme Court advocates on records Association versus Union of India in 1994, and now we'll go to Article 51, which is the last article in the directive principle of state policy, where it is a direction to the state under this article that the state shall endeavor to promote international peace and security, so also maintain just and honorable relations between nations, so also foster respect for international law and treaty obligations in the dealings of organized peoples with one another, and lastly, to encourage settlement of international disputes by arbitrations. And in that connection, we have to discuss some important leading case relating to the very relation between international law and the municipal law or the national law. And in that connection, we would like to discuss certain observations made under some important leading case why the Supreme Court. One is Beruberi Union and Exchange Enclaves case 1960, why the Supreme Court, and another important leading case Magan Bhai Survai Patel versus Union of India in 1969, and Varghese versus Bank of Cochin in 1980, also Gramophone Company versus Birendra Bahadur in 1984. The Apex Court made the following propositions as such. One is international treaties do not automatically become part of national law. They have to be incorporated into the legal system by appropriate law. And secondly, however, national courts generally interpret statute so as to maintain harmony with the rules of international law. And thirdly, national legislation, even if contrary of international law, has to be respected. And fourthly, or lastly, it observed that power to implement treaties belongs exclusively to the Union under Article 253 of the Constitution of India. So, in this above mentioned cases such as Beruberi Union and Exchange Enclaves, Maganbhai Shurvai Patel versus Union of India, Varghese versus Bank of Cochin, Gramophone Company versus Birendra Bahadur, Supreme Court made the following observations that we have just now discussed. So, we have completed directive principle of state policy, which is provided under Part 4 of the Constitution from Article 36 to Article 51, and in between all these directions given to state, even though there are certain rights, but these rights are not justiciable rights. They cannot be enforceable in court of law. That's why these rights are otherwise called non-justiciable rights which could not be enforceable in court of law. So we have finished directive principle of state policy, and in our upcoming video we would like to discuss part 4a, which was inserted under the 42nd Constitutional Amendment Act 1976, which provides fundamental duties of India's citizens and nationals.